You will note in our Wisconsin cases this month a decision from the Wisconsin Supreme Court that came down on March 29th. This is hot off the press, on a issue that affects a lot of family law cases, although the case itself is not a family law case. The issue is when and under what circumstances a court can utilize a third-party decision maker. The family law context is, it happens a lot in parenting, placement, custody cases, where the quote decision making is less legal and more something along the lines of child development and parenting. And a lot of times when these parties are constantly litigating and fighting about this, the costs and amount of time it takes to get into court is quite prohibitive. So it really helps to have a third-party decision maker other than a court. I mean, after all, if the parties are fighting on the third or fourth Monday of November about who's going to get Thanksgiving, to get into court 3 weeks later isn't going to do them a whole lot of good. So it helps sometimes to have a third-party decision maker who the parties can go to. It can be quick and it can be relatively inexpensive. The questions that arise is the circumstances in which the courts can approve or utilize on their own a third-party decision maker in these cases, and it also arises in cases occasionally involving financial issues, and sometimes in those rare cases where there's a lot of money and a lot of complex issues regarding discovery. There are some family law cases on it. A few months ago, we reported on a case called Rose versus Rose, and there's a case that is even older called Lawrence versus Lawrence, where they deal with the appointment of or utilization of a third-party decision maker in family law cases, again, in custody placement decisions. The Supreme Court case that came down on Wednesday is entitled Universal Processing Services of Wisconsin versus Circuit Court of Milwaukee County. It's cited as 2017 WI 26. If you're trying to find it on the Court of Appeals website, it is 2016 AP 923, and there's also a link to it in this month's Flu. The case involves a lawsuit regarding credit card processing, something about a credit card dispute between two companies, and the resultant discovery got to be apparently pretty much out of hand. At one point in the case, it talks about 10,000 pages of discovery material having been exchanged, provided, or requested, whatever. The circuit court judge hearing the case is Judge John D'Amato, one of the best judges that we have, and Judge D'Amato apparently got frustrated and said that he's going to appoint a referee/special master in order to make decisions regarding these discovery issues and other pretrial matters in the case, and he appoints reserve Milwaukee County Circuit Court Judge Michael Skorowski to serve in that role. Apparently this went on for a while. There was some proceedings before reserve Judge Skorowski serving as special master/referee. Apparently one side did not like the decisions by Judge Skorowski and tried to get the Court of Appeals to accept an interim appeal. Court of Appeals denied it, and then that side filed a supervisory writ before the Wisconsin Supreme Court. Case was argued in early November, and the decision, as I said, came down on March 29th, a couple days before I'm recording this. The first issue was a procedural one regarding the supervisory writ, and the Supreme Court was unanimous that the supervisory writ was the improper way of handling the matter to get it before the Supreme Court, that it didn't fall within the parameters. 8 of the 9 judges, however, justices on the Supreme Court, let me rephrase that, this is the Wisconsin Supreme Court, so it would be 6 of the 7 Supreme Court justices, decided that notwithstanding that supervisory writ wasn't the appropriate way to have the issue before the court, they would decide the substantive issues anyway. So the decision of those 6 judges was mostly consistent that the way Judge D'Amato appointed the special master/referee and provisions in his order violated both the Wisconsin Constitution and Wisconsin statutes. The court decided, for one thing, in the majority decision, that the term special master shouldn't be used, that the only term that should be used is referee, so I'll be using that term from the rest of the decision, rest of this recording, rather, consistent with the Supreme Court decision. The problem with Judge D'Amato's order, according to the 6 justices who decided to reach the substantive issue in the case, was that the standard for review of the referee's decision was whether it constituted an erroneous exercise of discretion. And the justices found that that standard essentially delegated to a third party who was not elected, was not selected by the parties, but merely appointed by the judge, powers that should be reserved by and utilized only by a circuit court judge. It's an interesting policy issue in terms of the extent to which our Constitution in the state provides that we elect judges, and the extent to which that the powers they have are reserved to them and can't be delegated in any form whatsoever. It isn't clear from the decision, and the thing that I find a little disappointing in it is the court states very clearly that referees are allowed under Wisconsin statute, and that under certain circumstances the court can appoint a referee, but it doesn't say how. In other words, I expected when I saw the case when it was filed and heard some of the arguments in the case, that if the Supreme Court reversed Judge D'Amato's order as being too broad, that it would at least give specifications as to what needs to be in the order, and that's not in there. My guess is that what the Supreme Court's looking for is akin to a family court commissioner in family court, which is that the decisions, for example, on first hearings and in many counties post-judgment matters, are initially decided by the family court commissioner, but the parties have a right to a de novo hearing before the circuit court. That hearing, if the parties choose, could be a erroneous exercise of discretion standard. It never is. Parties do request a hearing from the FCC. They've always requested it as to be a de novo hearing, and that preserves the right of people to have decisions made by an elected judge rather than, I don't want to say just somebody. Judge Skrowski's an excellent judge and a great person, but somebody who's not elected and isn't fulfilling a constitutional role under our state laws. Few questions are not directly addressed in this decision. One of them is, does this affect the use of private arbitrators in family law cases? There's a Wisconsin case from a long time ago called Franke, F-R-A-N-K-E versus Franke, that seems to limit the use of private arbitrators in family law cases in terms of preserving the overriding supervisory power of the courts in the case. Franke's not cited in this case, which isn't surprising because this is not a family law case. And again, it's not surprising because the court did not specify what orders would be acceptable in terms of use of a referee. All the case held is that Judge D'Amato's order was too broad in saying that the review standard was erroneous exercise of discretion. Secondly, there are several cases I mentioned earlier in family law, such as Rose and the Lawrence case, where parties have stipulated to a third party to make decisions regarding custody and placement issues. And it's not anywhere in the universal processing case about whether it makes a difference if the parties agree to a third party as opposed to a court appointing and utilizing a third party on a sua sponte basis. My guess again is that there is a difference between the two, and that this case wouldn't necessarily affect where the parties do agree and to stipulate to a third party. But again, it has to be read in context of, in family law context with Frankie, and also regard with the limitations of private arbitration when you're dealing with child issues. So it's an interesting issue. It's an interesting policy question as well, as to where the disputes have to be decided by somebody who is a constitutional officer rather than somebody who that constitutional officer delegates the decision to, or where the parties agree that rather than use the constitutional officer, they're going to find a third-party decision maker on their own. We'll see how this plays out. Got to read the case a few more times, but if you look for my column in the State Bar Inside Track online edition, that my next article is due in early May. I'll bet you'll find a few more of my thoughts and analysis of this case as I read it over and consider it a little bit further. So take a look at that and read the case yourself. It's a long case and an interesting one, and it affects any number of cases in this field for various reasons.